to this show, the lady from Canada, basically trying to follow this couple and trying to figure out how to do the return of property and compare it with like writ of habeas corpus and just try to hold your own court and keep them recognizing that you are holding court. And then once you're done with your court, how important it is to wrap up your court and go home. Don't keep talking to these people, because then now they're having a hearing, but it's under their rules. So, yeah, I talked to Jesse the other day. Is it Jesse or Jessica?
Jesse.
Jesse, all right. I talked to Jesse the other day for about an hour. We should have done it on the phone call. But, like I said, this might be good that she had a couple of days to think about what happened and see if she could see what I was trying to explain a little bit. The day before, Thursday or whatever, a couple of days before her hearing, she sounded really excited like it was going to go great. And I try to explain to people that, you know, 5-10% of it is paperwork. If you actually have to make a physical appearance in court, you can lose your court incredibly quickly. Or if you don't realize you are holding your court, you could just forget, oh wow, my court's over, I'm done, I get to go home. So, like a lot of times it's nice to just do everything with paperwork, and then it'll be 100% of your paperwork, and then you never have to appear in court. Makes life a lot simpler. Just not have to learn how to do paperwork, not have to know how to do paperwork and appear in court. So it just makes life a lot simpler. So I guess Jesse, we'll start with the you filled out you request. Start, I guess, basically where you set those folks up. You handed the clerk of court something the week before. She brought it to the court clerk, and then the judge actually came and talked to you folks, and then they set up a hearing. So I guess just take it from there if you want to explain to these folks, because there's a lot of people I can see who somebody from Canada, somebody in line from Canada, I've never seen them. There's a couple of people I've never seen. So if you want to just explain a little bit what's going on.
Okay, well, we originally had brought in our habeas corpus as well as a claim into the court clerk, and they gave the claim. We had to wait for the habeas for a couple of days for another court clerk to be in at the office. So our claim was handed to a judge to have a feedback, and he returned the claim to us with a letter basically asking us what our legal basis was for current proceedings as family court matters, and we were trying to make a claim. Threw in a statute in there regarding the Judicature Act, saying that it's discouraged to have multiple proceedings going on at once, basically. So we wrote him back a nice little letter that basically that our lawful basis going forward was that we had a case that we needed to move before a jury.
Jesse, everybody's saying it says Karl is very soft, and everybody's shouting on a textboard, please speak up. So yeah, can you go back just a little bit and say it a little bit louder, because nobody heard you. They said it's very, very soft, they said.
Oh, okay. How's that? I hope that's better.
That's a lot better. Okay, go ahead, take it away.
Okay.
Only 2 minutes. Go ahead, go for it. Repeat it.
So basically, we brought in our claim. He wrote us that little letter, basically asking us why we were trying to submit a claim when we already had family court proceedings going on. So we wrote him back a letter, basically saying that we have a claim that we want to move before a jury. And within about 30 minutes to an hour from there, we were in our own court with the judge, with the stenographer and the court clerk to have a listen to what's going on. So we presented both the habeas corpus as well as the claim. And he said, well, look, so I guess your main focus is to get your kids back, is what I'm understanding. And, yeah, that's our main goal, is to get our kids back home and where they belong. So he took a look at it, and of course we had to return our property. We had 3 points, basically, that the Minister of Social Development was administrating our property against our wishes and without right, and that they took our property without right, and that they are in possession and make possession of our property without right, and that we're looking to have them returned immediately. So he did debate with us for quite a while. The court lasted for about an hour, and he debated with us for quite a while over the word property. He really didn't like the fact that we were referring to our children as property, because then it was taking the jurisdiction away from them. They weren't able to apply codes and statutes and give rights if I'm calling them property.
Okay, did you figure out by now, if you listen to me enough times on these things, you know what property means?
That's right, proper to your person, like your hopes and your dreams. All that stuff that belongs to you. We put that blood, sweat, equity into there, and those are proper to us. Right,
so let me just tell these folks real quick. Thomas Jefferson and Benjamin Franklin, where they got it from John Locke. John Locke, and he passed it down to Thomas Paine. And all John Locke basically said was property is all that you claim is proper to your person, exclusive to all others within society, to your exclusive enjoyment. So enjoyment means to bond. It doesn't mean like happy, let's have a party. Enjoyment means that you could bond with it, that it's yours, and you have the right to be with it at all times.
Right.
So the government can't make a claim. All the government can do against you is file a complaint. So when it comes to property, it's all which a man or woman claims is exclusive to that person, exclusive to all others within the society. So the government can't make a claim for property. So what they have to do is they have to use fancy words like children or parents or moms. They have to use a different word than property. So when the judge hears you say property, he starts making a funny face like he just farted in his courtroom, because we don't like that word. That's right, because you have no control, jurisdiction, or power over what a man or woman claims is proper to them, exclusive to all others. So somebody in society is going to have to come forward with a counterclaim and explain how that property may be shared with the other person making the claim, or the thousands of people making the claim, or the billions of people making the claim. Then it has to be distributed evenly amongst, or the jury will determine who gets what percentage of the vested interest in that property. So the judge gets extremely upset whenever you try to stand in common law, because only a man can make that claim. An attorney can't make a claim for property. He can't do it. So what basically Jessie was saying is that she brought in a claim and then she did a habeas corpus. And I tried to explain to her, don't use the word habeas corpus, because she did write some nice things on it, but she wrote like an attorney would write. She wrote like, about 10 or 12 words in Latin. And what I try to say to you folks, if you write in Latin, or you write in Spanish, or you write in French, they could write their whole answer in Latin. So they could have the whole hearing in Latin. So just because, hang on 2 seconds, I got Mr. Tom. Hang on. Hey Jesse, take over for Tom Murphy on the phone.
Okay.
All righty, I'll be right back.
Okay. So essentially, to continue from there, we debated for a while about the word property over children, and in the end, his charm and his apparent empathy kind of won us over a little bit. So we let him change the word property back to children. And when we left there, it was kind of bittersweet. We're like, okay, we've got our case filed. However, it's under the word children now instead of property. So we decided to come home and make some adjustments. We decided to create an order instead of a motion, and we changed everything back from children back to property. And when we did this, we brought it back in and we had it refiled with the amended and a letter explaining the amendments and how we were disagreeing with the judge about the word children, and that they were our property and not children. And we re-served the Minister of Social Development the new paperwork. We originally had a pre-trial conference set up for April 10th on the third floor at 9 o'clock under their case. Once we had our habeas filed, they changed it from the third floor to the second floor, and decided to let us speak our case first instead of having the opposite party speak their case first like it was originally set up. So on the 10th, we arrived there in the morning. We had our court rules with us that we managed to get into the court, and when we first got in there for the hearing, the judge proceeded to hear the Minister of Social Development's case first. So we were a bit thrown aback by this because, they told us that we were going to be heard first. So we thought, okay, this is just one of their little, tricks, try to kind of beat us down a little bit, get a little fear in us or something to make it seem like they have the control, so to speak. So we let them go through their thing, and we waited. And finally they recessed to take a look at our case. So when we came back from before I get on that, when they started with their hearing, and they originally asked if I was present for this hearing and if my husband was also present, they were referring to us as Stefan Arsenault and Jonathan Little. So, of course, simply stated that we were there as a man and a woman presenting ourselves in case for the court. And he immediately jumped down my throat. Asked him for my name, and he's not playing games, and so I kind of calmed him down by just simply stating, "Why are you intimidating me?" He immediately kind of calmed himself down and kind of rolled his eyes a bit and started to proceed with the other party and kind of left me alone at that point. So then they proceeded with their hearing. That lasted about 10 minutes, and then they recessed for about 5-10 minutes so they could get ready for ours.
What time of day was that?
This was about 11 o'clock when we finally got in for our habeas.
All right.
And we get in there, and we handed the judge, we actually handed the prosecutor for the other side the evidence that we had brought in with us and whatnot, and our documentation. And she didn't object, so the judge also accepted a copy, and then he decided that he would recess for a few hours to have a look at all the documents and get back to us. So we came back from this recess, and he had a look, and we got to present our argument, so to speak. So again, we iterated that we were there as a man and woman presenting ourselves in case for the court. And we basically iterated how, the Minister of Social Development had unlawfully entered our home with a bond that was unlawful. They had a court order with no valid warrant or bond attached to it to be able to enter our premises in the first place. So that was like our main argument, along with the fact, of course, that they have no right to just come into your home. They had no claim to come into our home and take our property. And we had been after them, sent them notice after notice as well to return our property, that they had no claim. Either return the property or bring forth a valid claim for the property, and we'll hash it out that way. And it went on for a while, and of course they recessed to deliberate for the decision, and once we came back from the recess, it was for about an hour and a half. The judge came back in, we all came back in, and everyone was pretty confident that we were going to win our case.
So would you say this is a little bit out of the usual, what you used to run into? Or?
It was, we had a little more respect, and it seemed that the judge, like when he came back and he was spouting out, like he said, I understand that, Stefan, Louise, and he referred to us as our proper names, and, he understood that we were coming in as common law, and he understood that we were there as a man and woman, and, we thought for sure everything was going to go our way. He just kind of reiterated everything we just said and read all our documents for the record, all our affirmations, our rules of court, the whole nine, and then all of a sudden he said, however, and then he quoted some statute from the Child Welfare Act, and then said, order denied, and walked out of the courtroom. So we were just kind of left with our jaw open, wondering what just happened. So everybody was kind of that way. And then when
how many hearings did you have before this hearing?
We went to about 4 hearings prior to this.
And just tell people how the difference was. If there was a difference, it was about the same. How did they treat you different? Or would they treat you the same?
Well, the first time that we went in for hearings, we got thrown out of the courtroom.
Okay. Why?
Well, because we wouldn't own up to being the name that they were calling out for. We were standing there as a man and woman, and they wouldn't accept that as an answer. And they're like, well, if you're not the people we're looking for, then you need to get out of my courtroom, and they had it reported out. Okay,
so what's funny is basically you did the same thing this time, but I guess you wrote it out this time. The first time you didn't write it out? What happened?
The first time I didn't write any of this out. It was just it was stated on the record in the court, because they wouldn't allow us to file any paperwork, and the judge would not accept any of our documents in the court, and so we had to state everything out loud on the record ourselves. Nothing was, well, we had stuff in writing, but they wouldn't take it anyway.
Do you understand why they wouldn't take anything or wouldn't accept anything you were saying in open court?
Because it was their court, basically, right?
Correct. You get it close. Okay, that's really good. That's really good. And since it's their court, what does that make you?
Well, yeah, that makes me the slave in their court, basically.
Makes you whatever they wished you to be. They described you, they made you whatever it was, so they just want you to own up to that definition or that description. And since you would not play along with their rules, like, hey, we're playing baseball, we're going to play this way. If you say, no, I don't refuse to play baseball, I'm going to play softball, I'm going to play soccer. And they're like, well, you know what, we don't recognize that that's not the rules that we're playing under right now, so you know what, you can just sit down, have a seat, whatever, we'll throw you out, whatever, you know. Okay. Because you don't want to play, you don't want to play. Okay, so then how did the second or third kind of thing go, you guys?
Well, the second and third time, they kind of let us, they kind of let us come in, and we stood up as a man and a woman, and they accepted that, and he sat back, the judge this time, he sat back and looked at us in silence a lot, and very pensive, like he was really thinking about what he was going to say next, or how we were going to proceed, or so everything that we said, you know, it was like, we're a man and woman, and we're here to present ourselves to this case. And
back then, before I showed you how to just say it in 2-3 words, did you start to say all that living flesh, like you used to write to me, living flesh and blood, stuff like that?
Yes, we had that because originally we weren't keeping it quite as simple. You know, we were the living beneficiaries of our estates and whatnot.
I try to explain what, like I said, because it's really good that you really explain what's going on, because there's a lot of people who are watching, like say, a Divine Ministry, whatever these guys are, the Divine Madness, whatever it is, and they talk and talk and talk and talk and talk. And see, the judge is trying to say, are you competent? Are you crazy? Are you out of your mind? You know, because the judge never heard stuff like this. He doesn't watch YouTube. He goes home and has dinner with his wife and kids. So he has no idea where you folks are coming from. So you're kind of, you know, freaking him out. So see what I'm saying? If you can explain it to some detail, like I said, about this living. I've seen the script. I was like, holy cow. You know, this is a lot for a judge to swallow the first time, like seeing somebody, like, oh my God, what is going on here? So try to explain to them a little bit detailed, and because what we're going to do, what I'm trying to do is show people how to make it super simple. Say two things, go and get the hell out of there.
That's right. Well, originally we would stand up and say, you know, we are the living beneficiaries of the estate, trustee, administrator. He would try to make us sit or come to the bench, and we would say, you know, essentially, we're afraid we can't do that. We're here today to settle this matter, to full closure, basically, settle the account, set off the public debt and whatnot, have them pay all taxes and tithes, and you know, we were essentially also looking for a valid claim to be brought forward, and our argument was no valid claim was brought forward. They had no bonds. We had asked for their payment bond, performance bonds, and bid bonds. for their hazard bonds through their risk management department that they needed. Like we were kind of going off on a lot of detail like that. And
yes, that was great. That's what I'm trying to say to you folks. That all that stuff is wonderful. It really is. It's not bad. It's not bad to do that. It's like a Gordon Ball method. You guys repeating like 50 words like a broken record. Just to keep on repeating it over and over and over. But that's not going to carry the day. So what's funny is it's fine to do that little speech. But like I said, if you're freaking a judge out, it's kind of getting him nervous. Because he's never heard this, this stick or this spiel. But, and the only other thing that's bad is you're using a lot of legalese words that you really not aware of what these words truly mean. So even though you say, like vested interest or beneficiary, trustee, and all this other stuff, they're not, he's just judging you. He's just, you're putting on like a, American Idol show in it, and he's judging whether or not you have any idea what you're saying. So, like I said, I try to get people to say it's extremely simple. So that way, you're basically making one statement or one question in court, and you're waiting for one answer. And when no answer comes, like, okay, court's done. Carry out my order, have a nice day, goodbye.
Right.
So instead of giving him 1,000 options, saying, okay, well, which one should I attack first? And basically anything that you said, he could say, what do you mean by trustee? Can you explain that a little bit to the court? Could you have us confused again? You really don't want to do that. No. You really don't want to talk to these people. So, okay, go ahead. Then what happened, like, say, in the third or fourth hearing before this one, one of the ones before this one? Did they laugh at you, demeanor? How did they treat you?
They seemed to be a little more timid about how they proceeded with us. Originally, when we first started going there for the first and second hearings, they were just kind of, scoffing at us and no real respect or just, whatever with these people. They're back again. And as it proceeded, as we kind of kept sticking to our guns and not kind of bowing down into their world, I know we were confusing them to a certain extent, right, with all our madness, so to speak, but all of a sudden their attitude started to change a bit. They were a little more cautious, kind of walking on eggshells, like, well, we're not sure about these people. They seem to know a bit what they're talking about, but we have no idea what they're talking about, so maybe we should just be a little careful how we proceed here. And that's kind of the overall feeling we were getting. The very first hearing we had where we were thrown out, it was a judge by the last name of Noble, and he freaked out at us and yelled at us and had us thrown out of the courtroom. And on the third time we went to a hearing with him, it was different, and that's the one that we have the video posted on YouTube. He was very respectful. It was called, I believe, case dismissed by living beneficiary. And we went to our spiel again, essentially letting him know that we weren't government employees or agents, and then his jaw kind of dropped, and we were saying that, according to Section 32 and 52 of the Charter, that, we weren't government agents, that the Charter applied only to government employees, and so on. We'd rebutted all assumptions of being, governed by the government, that we were simply a man and a woman, and that we had him kind of, it was our wish that he quash the case, essentially dismiss the case for the Minister of Social Development. And when we brought that request forward, he said, okay, well, I understand that you have a motion, we'll address it at trial. And I said, well, no, I have a motion for you now. Are you going to address it or not? Like, either grant it or deny it, but address it. And he denied it. He just kind of talked over it again, saying, no, we'll address it at trial. And third time, I did that again. And
do you know why he denied it?
Because essentially it was his court, and he had the choice, basically, that I was asking him, and it was, he was basically, well, I don't have to do it. You're asking me to do something. You're not telling me to do it.
Right. It's basically never his court. It's the other side's court. And all he's doing is playing by the rules that are before the court. And you're asking him to do something that's not established in the rules. Like I said, if you play baseball and everybody knows it's 3 strikes, you're out, you're basically saying, well, we just want 2 strikes and you're out. And he's like, that's not the rules. You know, so we can't hear your wish or your demands to change the rules and just give you back your kids based upon whatever you're bringing into the game. Just because you bring another rule book into the game of baseball and show the umpire, say, look, I have a rule book, like say, you know, where we folks get this other stuff, you know, like a divine, you know, providence kind of thing. You say, well, look, their rule book says we could do this. And the umpire look at it, the guy in the black robe will look at it and say, yeah, okay, great. And we ain't playing that. We're playing this. Concentrate on what we're doing here, okay? If you can't concentrate on what we're doing here, we'll get somebody in to represent you and have you concentrate on what's going on here. These are the rules we're playing on. If you're not competent, if you don't know the rules, believe me, we'll provide you competent counsel, and it'll force you to play these rules, under these rules. So to kind of make a little bit of sense why they have to deny you all the time.
That's right. Yeah, it does.
Because it's not the rules of the court. Okay, so now the 4th time comes up, and you guys are getting ready. You went from this really long thing you sent me, like 9 pages long, and I think you basically got it down. I was working with it, and I think we got it down on 1 page. It was still a little too much for me, but you still did pretty good. You said you went to the clerk of the court's office, then she got the clerk, and then you got treated a little bit better because now they let you file something, or they accepted your paperwork.
Yeah, they actually had taken our paperwork and they were trying to help us out and kind of running around actually, you know, yes, sir, yes, ma'am, we'll get this done right away, just 1 moment, please. And when before it was just, no, and they wouldn't even look at it, wouldn't even look at our paperwork or look through it or just, no, that's not for us and we're not doing that here, and no help whatsoever on how to proceed either. Like, what will you not accept about these papers? Is there something we need to change? But they didn't offer up any advice or any suggestions. It was just a flat out, no, go basically get out of our office.
At one time, though, remember before this happened, you asked me, you said, but if I file under their forms, Karl, should I? And I said, yes. Why did I say yes? You should use some of their forms. And what do you use their forms for?
Well, their forms is just basically so they can, I guess, it goes by their format. They can say, okay, you know, it looks the same as every other one, I guess. But it's the rules that count the most.
Well, it's basically if you go into the post office. And the post office says, you know what? You put the return address on the upper right-hand side. You put the address the way you want it to go. You put a stamp on the upper right-hand corner. So just because you've stockpiled a envelope, according to the U.S. government and maybe the evil Canadian government or whatever, the evil, you know, world government style or format of your envelope, it does not negate any of the claim within inside the envelope. Just because you formatted it so they could accept it into their court, into the court's office, you could also make the very next thing say, just because this thing is attached to this suitcase, we had to put a suitcase in a certain wrapping. We had to wrap it in brown paper. They didn't want us to put a golden suitcase, you know, through the postal service. They said somebody's going to steal it or whatever. Let's just say suitcase. They wanted you to wrap it up in a brown, plain wrapper. So you had to wrap it up in their forms. You had to file their forms the way they kind of want you to do it. That's fine. It's kind of hard to do. It's kind of like, oh man, this is going to blow my case. I'm supposed to stay away from statutes. I'm not supposed to do things they want me to do. Oh my God, you know, I'm going to blow everything. It's like, nope, because then you put the next page and says, this does not negate any of the claim within this filing. You see what I'm trying to say?
Yep.
So, okay, and then go to where you said they were starting to act more respectful to you when they saw, like, then you only had how many pieces of paper did you try to file then?
Then when we brought the habeas in, we had just the 2-page for the habeas. The first page was the habeas and the second page was the signature page. And then we had our 1-page claim with the signature page as well. So it was just a total of 4 pages, and then our little, like the copy of the fraudulent court order that they used to enter our home as evidence that they came in unlawfully.
So the rest was just evidence, right?
Yeah.
Okay, that's beautiful. So how would you say that was different from the first couple of pages that you were trying to file? what were you first trying to follow? Was it a lot more voluminous the first couple of things, or?
Most definitely. The habeas itself.
One of these women, there's women that they're going to listen to this, so one of them.
Definitely, yeah, the first, the habeas was 9 pages. However, the habeas itself was still only 2, but we had other paperwork they wanted in there, like an order in French and in English. They wanted another type of form. Basically, they wanted us to do all their work for them, give them all their forms, so all they have to do is stamp it if it's approved. So,
right. That's a good thing to do, that you did the 9-page habeas. That's not bad. But what did I say about a 9-page habeas? What should you consider that? Do you remember?
Well, it was just much. It was still way too much. You know, they just needed simplified.
What a habeas is, stylized in the manner they want. It's called an exhibit.
Yes.
That's not your claim. It's an exhibit. So you make your 2-3 sentence claim, and you attach C Exhibit A. And then it's the 9 pages, photos, kids' birth certificates, whatever you want to do. It'll be 10,000 pages long, the exhibit. The claim is very simple. I demand the immediate return of my property, unless somebody else comes forward and makes the claim for the child, and the next sentence would be, and I demand compensation of $10,000 a day if this demand for the return of my property does not commence post-date. So thank God I said it, so you guys can go back and download it and put that little 2-sentence ditty claim and attach your habeas corpus, say, compare that with Exhibit A. And then they look at the Exhibit A, oh, okay, she's kind of doing a habeas thing on us. She's kind of doing a habeas thing. So because if you are doing a habeas thing, it is a statute. It's established in law. They can only work certain ways. You basically give up your claim because you're putting it in the mercies of the guy in a black robe.
Right.
And that's what you don't want to do. So doing is making a claim for your property, and you're just basically saying that you want the property returned to the original source, the original jurisdiction, the origin of its jurisdiction, which was you. So you have the full control of that thing from its origin, from its inception. There you go. So that's how you basically do it. So like I said, I don't think you really grasped tight enough what I was trying to say, because like you said, you had a habeas corpus hearing. You referred to the judge, this is not a habeas corpus, this is a return of property hearing. That's what this is. He's like, well, you stand corrected. No, Your Honor, you stand corrected. This is my claim, and I'm claiming I want my property returned to me unless somebody's coming forward right now and making a claim. Does that property have a vested interest in that property? Do or don't they? If not, I'm going home, and you could take this order, bring it to the court clerk, and let her stamp it as you witnessed that nobody came forward and made a claim for the property. All I want you to do, Mr. Man in a black robe, is witness that nobody came forth today and made a claim for my property. That's all I need from you, is a witness capacity. I don't need you for any other thing. So you see what I was trying to, like I said, maybe a couple of days gone by now, and you kind of see where I'm trying to go with this?
Oh, yeah. And plus, when you and I were discussing this before, one of the big mistakes that we made was in our court rules, we basically said, we'll accept claims from this time to this time. And
right.
We were still there past the time that we said we would be accepting claims.
Because it's kind of funny, like I said to these folks, it's funny, I was kind of going around with you, and I was kind of, I was a little upset on my side. That you can't ever tell when I'm like, oh man, I just wish I was over there and just, tell us, man, do it this way, so, but I got to be real nice on the phone calls. So, I'm trying to say to you, take the claim, accept claims from 9 o'clock to 11 o'clock or 12 o'clock. Give them a couple hours for anybody to come in and make their claim for that property. Try to seem reasonable. And you're like, oh, well, I'll give them 10 minutes. I was like, no, don't give them 10 minutes, because that kind of sounds like kind of mean. I know you want your property back, but it's not like cricket. It's not the proper English thing to do. Give them a little bit, because they're going to lose anyway. Who cares?
Yeah.
Who cares? Give them 3 hours. Who cares? Nobody's going to show up anyway. You wasted the day going down there anyway. You know what? You might as well just sit around, stand around, just wait for somebody to come forward with a claim. You gave fair warning. You gave plenty of time. And like I said, folks haven't heard this because we did this on a Thursday. What we usually do with the women on Thursday, we talk to the families on Thursdays. And Saturdays at the Jack, we usually get a pretty crazy crowd in. So the Saturday people who are listening now might not have heard what I said in the past. But all I basically said was, if Jessie found a ruby ring in the street, what she's supposed to do is the honorable thing. She she's supposed to go and put it in a newspaper or go to CNN, say, look, I found $1 million ruby. I got this appraised. It's worth $1 million. You know, I'm going to really feel bad with some little old lady, you know, the Titanic, you know, ring. I'm going to feel real bad keeping it. So, but if somebody wants to make a claim for this ring, I've got the ring. If you could tell me what's inscribed inside the ring, I will give that ring back to you. I'll give you 60 days, 90 days. I'll give you 21 days to make your claim. And then I'm going to keep it. So it goes all around the world, the claim. And all of a sudden you get billions of people trying to guess what's inside that ruby ring. So when you convene your court, you can make the rules even simpler. Say, you know what? Instead of just getting these mass flood of claims, like what happened with Anna Nicole Smith, when she had $1 billion baby born in Bermuda, the judge just flat out said, if anybody wants to make a claim for this $1 billion baby, make your claim known to the Bermuda court. So you had billions of guys all around the world making a claim that that was their baby that they took with Anna Nicole Smith. So that taught me, don't make an open-ended invitation to make a claim. Say, look, you want to make a claim, bring your butt down here to Bermuda, spend $1,000 for a plane ticket, and then file a claim. Stand here in court and hand somebody your claim and hand them your DNA test so we can knock this thing out in 2 minutes. So that's all you're trying to do, is trying to establish the rules of the court. So what you did with me that one day, it was great. We started typing it down small, and we got really good with the rules of the court. I think we got down to like 8 or 9 rules. Yeah,
I think we had about 8 rules on there.
That's magnificent. It was like basically one sentence each, and not a run-on sentence. It was like boom, 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 done. And once you say I'm a man and a woman once, boom, we didn't say it again. Right. You established man and woman, Jesse, and husband, We said, you know, like said parents or said man, said woman, whatever we did, we just referred back to you just in like 2 words, like said parents or said, you know, couple, whatever.
Exactly.
Don't keep repeating we, man and woman, you know, blood, flesh, You know, it's said parents or said party or said interest, you know, said something. S-A-I-D, said something, and it refers back to whatever you're, you know, defined in a sentence above, so you don't have to keep repeating it like a robot. It looks kind of silly.
That's right.
So
definitely cleaned it up a lot doing it that way.
Oh yeah, and the judge really appreciates it. Believe me, he'll really appreciate it. And so what's funny then is, with that ruby ring story, let me finish that up. If somebody comes into New Brunswick and you say, I'm going to hold court from 9 o'clock to 12 o'clock, and it's 21 days later, and 2 people show up, 3 people show up, and they take a guess for the ring, because it's expensive to go to New Brunswick. But if it's $1 million ring, and they really think it's theirs, they're going to actually make the effort to show up at 9 o'clock. So you don't just do it from 9 o'clock to 9 o'clock to 9:10. That was kind of silly. I was like, no, that's not really nice court. You know, it's like, hey, come on, she might have got stuck in traffic, and then how do you get up? So you give him a couple hours. You toss him a phone, give him a couple hours. Say, well, maybe that got stuck in court, you know, and traffic, you know. We'll give him a couple hours. We'll give him till lunchtime. Give him till 12. So you give him till 12, and 2-3 people show up. The first guy's not even close. And the 2 women show up, 2 old ladies, like, wow. She knew what was in the ring. She knew what was in the ring. Wow. Then you're going to have to say, okay, when did you first possess the ring? When did you first possess the ring? And then you start going into evidence. Did you have any proof that you had this ring prior to this lady? Because at first, when you're just making a claim for the ring, as long as she said, you know, in God we trust is written in it backwards, it's like, yep, that's yours. Here you go, lady. You're not going to ask her for evidence. You're not going to ask her for exhibits. You're not going to ask her for eyewitnesses, third-party impartial witness. You'll say, you know what, lady? That is definitely your ring. God look and God bless. You know, I'm glad I found the original arm. Have a nice life. But when 2 people make the same claim, then you got to do a King Solomon thing. It's like, okay, we'll cut the ruby in half. You know, who wants us to shatter the ruby in half and make it worthless? So then it starts getting a little tricky when you have 2 people making a claim. But you know, and I know for a baby, that's not going to happen. There's only one mom, and you're pretty sure that there is no way in the world another mom's going to come forward.
That's right.
See what I'm saying? So it was pretty much a rigged game. So it really didn't matter if you gave him 3 hours, you know, or give him a year. Nobody was going to come forward. You knew nobody was going to come forward. So now you kind of understand a little bit. So like I said, what you did is you said, Ed, you made a little bit of a mistake by sticking around past 9:30.
Right.
Okay. And can you tell these people what this one guy asked me, did you ever have to bring any witnesses into the courtroom with you?
Not so far.
Okay, that's fine. They just said thanks. It's somewhat very important. I don't really read the screen when I never read the screen. I'll tell you folks. And can't do two things at one time. I'm not that kind of guy. I do one thing really good one at a time, but I can't do two things. I'm terrible at it. So what were you supposed, do you remember? Okay, so let these folks hear a little bit. What happened between like 9 and 9:30? What kind of happened? Can you set it up a little bit?
Well, between 9 and 9:30, we were waiting out in the hallway on some chairs outside the courtroom for other cases that were being heard at the time, that were kind of going over their time. We were scheduled to begin at 9, but we had to wait for other cases to finish up.
Okay, when you had to wait for other cases to finish up, what time were you summoned to appear?
We were summoned to appear for 9 o'clock.
Wow. So what if you were summoned to appear, what you said, somebody else was summoned to appear at 8 o'clock or 8:30?
We assumed that they had to start there for 8:30, 8:45 maybe, and they must have gone over. And they recessed, and instead of taking us back, they just finished their case. So they recessed and then took their case back into court, and then it went on until about 11 o'clock or so before we got in.
Okay, so now does it make a little bit of sense why I say, you know what, just put it down for a couple of hours?
That's right.
So that way you could say, hey, did anybody come to this courtroom between 9 and 11? We just walking in here at 9. You know, we would reserve the room for 9. But obviously, you know, if somebody's, discourteous and, discourteous, they believe that they could occupy this room when we had it reserved for us at 9 o'clock. So it's like somebody had, at the clerk of court's office, felt that they could be disrespectful, and they could, and to schedule two parties to be at the same dance at the same time. Like we were all dressed up here to go to, our formal dance, and she had scheduled this courtroom for somebody else at the same time. That's like really discourteous. So, but anyway, like I said, you make it go for 3 hours then. We can make it go all day. It doesn't really matter. You say, I'll make it from 9 o'clock till 4 o'clock, 5 o'clock. I don't care. Anybody comes into this room, with a claim, let us know. And you just, that's how you hold court. That's actually called like holding court. You're holding court. You're waiting for claims to come in. That's holding court. You're considering that venue your place of business. It's your courtyard. Or like I said, like when you, just like I'm sure you folks have courtyards up there in Canada where, they have like a coffee, club over here, and you walk across, you got a bookstore. It's a court.
Right.
And everybody conducts business there. That's what you're doing. You're conducting business in this public building. Not a private building. It's a public building. So you get into there at 11 o'clock. Did you explain to them that, hey, we had a claim hearing, we had claims going to be submitted here between 9 and 9:30? Did you bring that up or not?
No, I didn't bring that up.
Okay. Do you understand why it's really important to bring it up?
You might have to go back over that with me.
Okay, well, it's really important to bring it up because that's the only business you had in that venue inside of that public building that day. You had nothing else to talk about. That's all you wanted to do was accept claims that day, at that time, and get out of there. That's all you wanted to do. And all you wanted to do is get somebody who is assigned by the court clerk's office, some guy in a black robe. It could be the bookkeeper. I don't care if he's the accountant, and he's just assigned to be there that day as a witness. So when you create your order like Jesse, as no, person came forth on this court on this day, from 9 o'clock to, 12 o'clock to make a claim, I order the immediate return of said property, see attached Exhibit A or whatever. Or you could actually put it in the order, the actual name of your property. I would demand the immediate, and you can make 4 orders. 1 kid, 2 kids, 3 kids, 4 kids. That's fine. I return the name of Baby Joe, Baby Billy, Baby Bob, You can say, and then make it 4. So that way when you give it to the sheriff's department, they'll go find each kid in case they separated him and put them in multiple locations.
Right.
Make each separate order. That's fine. And then what you do when you make your order, you sign your name, you put your thumbprint on it. That's fine. That's cool. And underneath it, you put witness. And then that guy in the black robe would witness it. And then underneath it, you write on your order, clerk court, or court clerk. And that's it. And then she would sign her name, the witness would sign it, the court clerk would sign it, they put the seal on it, and now you have an order in which you could go down to the sheriff's department and have them executed on your behalf, or you could stick it on your mantle and never do nothing. But now you at least have your order, you have your judgment. And the order's been, acknowledged as a legitimate order. So now you could actually have it go executed if you want. If you don't want to execute it, don't execute it. It's up to you. So like you said, 11 o'clock, thing started? How did it start? Like, what went on?
Well, it began first off by the judge addressing the Minister of Social Development's application first, instead of our case first.
What was the application for?
The application is for custody of our children for 6 months, even though they've already had them for 4.5.
So they wanted them for an additional 6 months?
For an additional 6 months, and now they're trying to go for permanent custody.
Right, but this one that day was for 6 months, right?
That's right.
Okay. So what did you do when they started talking?
Let me try to remember this now. When they started talking. First the judge said what they were there for. They were there for the matter of the Minister of Social Development's application, checking to make sure if there were any preliminary issues for the trial and whatnot, and we're checking to see if all the parties were there. So they went through, and once they came to us, we didn't confirm our name as he requested. We simply stated that we were there as a man and woman presenting ourselves and our case for the court.
Right.
And that's when he kind of jumped down my throat right away, and basically, I asked you a question, and you're going to answer me the way I asked you, and this is my courtroom, and blah blah, and then I looked at him and said, why are you intimidating me? Very just matter-of-factly and very sweetly, and then he just kind of calmed down, and because it's all on the record, I guess, and he said, well, are you not, just ask Arsenal. I am a woman here presenting myself in case for the court. So he finally just basically gave up and big rolled the eyes and the sigh, sat back in his chair, looked at us, and then just decided to proceed with the other party.
Can you still kind of see why it's going on the way it's going? Can you tell everybody why, so I don't have to tell them?
Well, first off, I disobeyed my own court rules, so I'm in contempt of my own court already because I'm there past the time I'm supposed to be. So it technically wasn't our court anymore; it was his court. So he was making the decisions then at that point.
So what I'm trying to say is, what's happening is you just wanted to establish court to accept claims. Other than that, there was no other business for you. There was no other business for court that day, as far as you were concerned. There was no business for the Arsenal court that day. Anything else was moot. It didn't matter. It had nothing to do with you.
That's right.
Yeah, less what these people are talking about, you couldn't care less. What 6 months they want, 6 years, 60 years, they're just trying to do it to intimidate you, scare you, and shake you off your claim. They're trying to get you to understand you better start playing ball, or you're going to kiss these kids goodbye. Did you kind of feel more that way? Like we were trying to intimidate you?
Oh, definitely.
Yeah, so that's so I'm pretty accurate of what like I said, so you could definitely tell, oh, Karl, you've definitely been to family court before.
Yeah, definitely, because the social workers and whatnot won't even talk to us anymore. They've got the big hate on for us, and
they won't talk to you anymore.
No, they won't let us see the kids at all. They won't answer our phone calls or anything like that. They
you can see a lawsuit is coming. There's no doubt about it. When a lawsuit is coming, they'll tell everybody, don't say a damn word to these people. Everything you say will be used against you, and these people will take your social service pensions and your bank accounts, and they garnish your paycheck, and there's nothing the court could do to stop these people from suing you individually in your individual capacities. Don't say anything to these people. You have an attorney that represents social services. Let the attorney do all the speaking for every single person in this social service organization. You see why they're claiming up? It's not because they're claiming up because they don't like you. They're told, you shut your mouth or this lady's going to own you.
Right.
Okay, that's what's really going on. Not whatever you think might be going on. That's what's really going on. They're now being warned. You're going to be sued. You're going to lose everything. You better just let us take care of this because these people are going to win. So now everybody's just told to shut up. Don't testify. Don't do anything. Don't take the witness stand. Don't do anything. So now what's the other thing that you really missed that's really important? You realize why they did what they did to you.
I'm kind of hard to think about that.
You said it earlier, believe it or not.
Did I already say it?
I did a little earlier. Why did they treat you, the very first hearing, why did they not respect you when you were talking? Why did they totally...
Well, because, first of all, we talked too much, and second of all, they didn't understand anything we were saying. We were just confusing the crap out of them.
The reason why they can't recognize you is because you haven't made a claim yet. You have no case before the court. You still, to this day, have no case before the court. They can't see you in your capacity in which you wish to stand. They still see you according to the social services or Canadian rules or whatever.
That's right.
You have to file a claim. You have to get your own case in there, your own suitcase with your own claim, with your own accoutrements, with your own witnesses, with your own exhibits, and you need to make your own claim and drag and define what the social service thing is and drag it into your case. See, right now they believe that they are the controlling party. Of course they wrote the rules for them to win.
That's right.
So you got to write your rules for them to lose. And there you go. And then that's when you get it up to the jury. And then the jury will determine whose rules work for them. To the jury. Not for you, not according to any constitution, not according to any Bill of Rights. The jury is going to talk it all out. And they're going to determine whose rules does the society like. And that's why I warn you. You might get a jury who say, you know what, you guys are a bunch of wackadoos. You know what, I'm glad social services took you kids because I'll take them too. So that's why you got to be careful sometimes when you ask for a jury. Honestly, it's actually better to go before a black robe one when it comes to something like this because the trump card is the common law. Trump card is the claim over the complaint. So if you have a claim that you won the lottery, and you go to the lottery commission, the lottery control board, you say, look, I got the claim ticket I won. You're going to get the cash right there. If you're going in and saying, well, I'm a woman, gay, in a wheelchair, and I'm Hispanic or black or Oriental, and I'm Buddhist, so you discriminate against me from winning the lottery, so I'm going to file a complaint that only white people seem to be winning the lottery up here in Canada. Your complaint is basically going to be falling on deaf ears because everybody says you're ridiculous. That's not the rules of the lottery. What do you want us to do for you? Well, you just gave it to that white lady over there a lottery winnings. I want to because she brought a claim. She had a claim. You have a complaint. Well, you know, what are we going to bring? Everybody who lost the lottery this week, we're going to pay them too? So see what I'm trying to say? When you have a claim, they understand that trumps the state's complaints. If people say that's a complaint, if we lived in France, you'd lose. Because that's just the way they work. It's on the Napoleonic Code. We got lucky, and some great reason, our great-grandfather somewhere in the past decided, you know what, this is going to be common law. Because we don't trust the people who write the codes. We don't trust the people who write the laws. We just don't trust them. Because they're usually lawyers and guys who went to college and know how to wrangle words. So you know what, the guys who actually are competent to read and write, they always try to figure out a way how to get over on the common people who don't know how to read and write. So the next thing will be enslaved to these people who write the codes. So that's why in this country, and that part of Canada as well, also believes the same thing, that our grandparents were wise enough to say, you know what, even the people who can't read or write, they have just as much right to claim property as a guy who would wrangle the words and, talk, snappy in court. As long as a man comes with a claim, you know what, it doesn't matter how well he reads and writes. We're still going to give the guy his day in court. So thank God our forefathers decided to do it that way.
Right.
So, what else would you like to add in there? Do you have anything you'd like to add in there?
Well, at this point, we haven't given up. Now we've got our claim that we're preparing. It's still just going to be the one page, and we're going to go file that on Monday. And
Right.
start the process or Tuesday, depending on when we can get into town again. But, yeah, we're going to try this again, and this time try to do it the right way, file our own claim with our own court.
It's not
filing it into theirs.
Right. Like I was saying to people, there's no definitive right way, wrong way. But it's more of to me, it's more like, are you confident? This is a confident way. You could do it the legal way. You could do it the law way. You could do it the admiralty and divine comedy way or divine ministry way. Whatever you guys want to do, that's fine. There's nothing wrong with it. It's a different style. But this is the style that we are fortunate enough to have, in this nation that will work in our behalf, because somebody was smart enough a couple of hundred years ago to say, hey, you know what, let's make it this way in this country. And like I said, when I said to the U.S. Marshals, I said, look, eventually, all my common law nonsense that I'm teaching everybody is going to get thrown away. And we're going to go into a code world. It's going to go into a police state, and everything is going to be under a code. And there's just going to be people who are going to take this over into a nanny state and tell me what's best for me to eat. And it's going to be according to a code. And and the jury will be just told, you have to do what the code says. Regardless of what the jury believes, you're going to have to do what the code says, because it's going to be a code world. And that's the law that everybody in society consented to, because you're elected politicians. And those people went and wrote the laws for you, which bind you into those contracts, because they're your lawyers. Since you're too busy doing whatever you're doing, you're allowing representatives to bind you into contracts with the rest of society, because you don't want to do it yourself. So you trust people to go be your attorney, to be a legislator, or your congressman, or your minister of of whatever you guys elect up there, and there you go. And that's how you get your code world going.
Okay. Now, Karl, do you think in our case that it would be more beneficial to go just before a judge or to request a jury? Because the judges don't seem to like us very much, so we don't know if we want to place our trust in just a man in a black robe.
Oh no, believe it or not, I really no, because he knows the law. He knows the law a lot better than the jury does, believe it or not.
Yeah.
Oh yeah, and he knows that he's going to make himself liable. Like I said, when you talk to him, you got to make sure. Like I said, I forgot who I was listening to not too long ago. They said, like the prosecutor called the judge by his first name, and then he tried to call up the guy in a black robe by his first name. The judge went bananas. So what's funny is if you write to the man in the black robe or talk to the man in the black robe in his first name, you're making him personally liable to you. If you call him your honorable majesty, whatever you guys call these guys up in Canada, your magistrate or whatever you guys call these folks, you're basically going to let him hide behind a robe. And then he's not going to be liable for anything. You say, hey, Bill. You're like, what? Bill, your name's Bill, right? Yeah, okay. Well, did you witness anybody coming in here today, Bill? Well, you can refer to me as magistrate. It's like, okay, so Bill the magistrate. Yeah, okay, Bill the magistrate. Okay, Bill the man, Bill the magistrate. Okay, but you do know you're a man, right? And he'll say, well, absolutely. I say, well, okay, well then it's magistrate it is, as long as you realize that you're a man. You're in the capacity of a man right now.
Right.
I'm looking at you as another man. I said, well, don't look at me as a man. Look at me as a magistrate. No, I'm not going to do that, because this is common law. If you have anything to say in a common law court, only a man can speak in a common law court. If you have anything to put on the record, you have to do it as a man, not as an actor, not as a representative. I'm holding to you. If you want to put something on this record, if you want to open your mouth and say something, the only person who's going to be able to put something on a record is a man. See what I'm saying? Like I said, it's like when you press a record. If you're Elvis Presley can't let his lawyer go in with a recording studio or deck the records and press a record from him.
That's right.
It's ridiculous. It's not an Elvis Presley record. It's a lawyer record. So see, like I said, I hope like this kind of stuff is starting to make it calm people down a little bit when I talk, and try to explain things. Extremely simple. I can't imagine any simpler than I explained to folks. So what's great is you got an exhibit now that nobody made a claim on that date. So you gave them fair warning. You gave them notice. You gave everybody the opportunity to, make their claim. And they didn't. So that's great. So you really don't have to wait for 21 days for anybody to answer, because you just said, hey, you know what? I want it now. You could basically say Monday, if you write it like that, you could basically say, hey, I want the return of the property now, since Judge Bob, no, don't say Judge Bob, say Bob, the man who sits in the capacity of the robed one that day, or whatever you call him up there, the magistrate. What do you guys call him, magistrate? They're
magistrates here, yeah.
Yeah, okay. So, Bob, the man sitting in the capacity of a magistrate witnessed firsthand that nobody brought a claim as ordered on, see Exhibit A. I demand the property returned immediately, post haste, and if anybody interferes with the return of property, I'm going to charge that person $10,000 a day until property is returned. There you go. That's a nice, easy, simple claim. So good thing I said it, record it, and now go back and listen to it because I go say it again.
That's right.
I just don't know how not. Like I said, if I said it again, I'd probably mix the words up a little bit, and I'd really confuse the court guys. I'd probably add something that takes them away. So better to go with what's in your gut and what's in your heart and just say it, because you're the one who's going to have to keep repeating it in open court, not me. So kind of have an idea of where I'm going, and then just twist a little bit if you have to. But try to make it as simple and as plain as just what I just did. I did not use one legalese word. I did not use one language other than plain, simple English that every jury person who's going to be seated will understand. I didn't use any Latin legalese. I didn't use, Spanish. I didn't use any tricky phrases. I didn't use anything fancy. It's common, one-syllable, two-syllable word, and I'm done. And it really drives them bananas because they can't answer it. There's nothing to say. They're like, well, that was pretty simple. What are we going to do? Well, how can we tell them no? We better have a damn good reason why we're telling them no, because I can't think of one.
Yeah.
See what I'm saying?
Yeah.
Pretty scary.
so scary. Is it so simple?
Yeah, because like I said, it really freaks people out, because you can't believe the emails I'm getting. It's like, where am I losing you folks? I can't imagine any simpler. And people try to keep using this fancy stuff that they want to be lawyers, because I guess well, how long have you guys been doing this? Just the 4 months, or have you been involved with this stuff for years?
Well, just this particular portion of the law we've been in for just since this has happened, the last 4.5 months. But we were studying a lot about government and how the laws technically are like the codes and statutes are not what's supposed to be law. We've kind of been into that for a couple of years, about a year or two now. So
just enough to just totally mess up your brains, just to totally confuse the bejesus out of you, right?
Yeah.
So like I said, do you understand, if I had a teenage kid and I just explained to him how to do law, how much simpler his life would basically be if he just listened to me for an hour?
Yeah, exactly.
Well, that's what happened with me and my mom. My mom was an IRS agent, and I was carrying groceries for her, and she wanted me to go outside and fix a car. So then we just got to a discussion on our way up the stairs into the kitchen across the living room. She basically explained to me everything about the IRS and the government. By the time we got to the front door, and the time I got to the kitchen, she opened up the IRS book. She told me to read the front cover. She said, what do you see in the inside cover? Welcome to the IRS 1040E form. This is a voluntary compliance system. She said, what part of voluntary don't you understand? And then she just closed the book and said, no, Mom, I really want to know, because I taxes, what pay taxes? She said, you believe you have to pay taxes? Yes. She said, let me try this again. You believe you have to pay taxes? I said, well, yeah. She said, okay, let me try this. You believe in a tooth fairy? Well, no. She said, but you used to, right? You used to take $1 when I put it under your pillow? It's like a quarter. Oh, yeah. But now you don't, right? Yeah, okay. You believe in Santa Claus at one time? Yeah. You don't believe in no more, do you? Well, no, not really. No, you don't, right? No. Okay, I don't. Okay, good. You believe you have to pay the IRS? Yes. She said, okay, now watch this. You believe in Tooth Fairy? No. You believe in Santa Claus? No. You believe in IRS? No. She said, go out there and fix my car. That's all you need to know. And that's the way I've been living now since 1987. She was boom, done. I could talk to you folks on the internet for days and weeks and months on end, and I'm still not going to make you understand as simply as my mom did. She's like, look, you go fix my car, I'm going to go fix dinner. You do your job so I can do mine.
That's right.
And boom, we're done.
Yeah, I think that our problem is, for the most part, most of us have been, we've been taught our whole lives that all this stuff is complicated and leave it to the people who know what they're doing.
Right, because what I'm saying is I can tell these people like a broken record how to do it. And they're just in total fear. And they don't really know. Should they trust me? So like I said, I trusted my mom, you said, well, Karl, come on. She had such high clearance in, the federal government. She was one of the best collectors for the IRS in New York City at all time, but she was a sweet lady. And she was like me. She was a sharp lady. But she wasn't stupid, and she was gorgeous. So it really was easy for her to make settlements. Because she'd say, you don't make a settlement with cute little me. My boss, Bubba, he's in a bad mood this day, so you sure you don't want to work with me, because, I've got to deal with you. So believe me, my mom had so many completion rates, it was scary. Just like if I was doing it, I'd have so many completion rates with people like, come on, work with me on this. let me get you out of here. You know, don't you want to get back and do something else good? You know what? Let's just make it how much can you handle? Blah, blah, blah. And make it as painless as possible, you know, and just get on with your lives. You know, like I said to you, they want you to fill out their forms. Hey, you know what? You got to consent a little bit. You got to give up a little bit. Because they don't want to make it seem like this is going to be a runaway freight train. That all you have to do is one paragraph, one sentence, two sentences done, and they're like, holy cow, if everybody figures out it's as simple as this, how are we going to hold the floodgate back? We're going to have to give these people as hard a time as humanly possible and try to find a loophole. And, you know, like, they're all scrambling. The guys in the black robes, the clerks, and the social service, they're all scrambling and how to try to interfere with your ability to hold court. They're doing everything in their power to mess with you.
There are.
You don't want to lose control of the court. And you're gonna take over control of the court. Like I could walk in and take control of the court in like 2 seconds. It's scary. They don't realize what I did. And by the time they realize what I did, they're like, oh my God, this guy's got the court. You know, it's funny. So like I said, if you can walk in there and you have to actually make a physical appearance, I'm telling you, all your paperwork, 5%, 10%, they really don't care. They'll read it, just make it a little short sentence, it doesn't really matter. Because you can't hold court. All the paperwork you did was for nothing. You're wasting your time.
Right.
How much you study, I don't care how much you do. Like I said, my mom told me very simple with the IRS, good. Man, anybody want to come and take me in and go around with me with under their little system, under their little beliefs, I'll say, okay, boom, 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 boom. I was like, there you go. Now, what do you say? They'll say, well, we can't say because we're representatives and we're not Mr. or Mrs. IRS. That's right. When you get Mr. and Mrs. IRS here to make a claim that I cause the direct source of their harm, that I'm the direct source of the loss of their income, that they accrued damages, financial damages, financial loss due to my acts, I will be more than glad to compensate Mr. or Mrs. IRS who shows up. Until that day, I'm going to let you go off with like a warning. Don't bother me again. I'll dismiss this without prejudice. If Mr. and Mrs. IRS somehow magically appears with a properly submitted claim to court, my court, we will be more than glad to entertain any claims and we'll be more than glad to compensate them for my wrongdoing. That's it. I'm done. There's nothing they can do because we're not in France yet. Yet. One day, my stuff is going to be dribbled. Because, oh, listen to this crazy guy in this old talk show. Oh, remember that? Oh, that guy's so funny. He's like Soupy Sales, you know, he's like Don Rickles. Listen to this guy talk about common law. Oh, he's so funny. I'm serious. Our kids are going to be doing that one day if people don't wise up and realize how simple it is. It gets caught up in this crazy loophole. And in this loop the attorneys got us in. Because that's how they control you. If you never hold court, you never got control. It's always under their control. It's always their court. Simple. This stuff is magically simple. Thank God this thing is being recorded because I really think this is going to help a lot of people. And thanks a lot, Jesse, because are you feeling a little bit better, a little different? I mean, how are you feeling as days are going on?
I feel better. I mean, we have our moments because we did receive the other day some information that the social services are trying to really bury us and take the kids away for good, terminate our parental rights, and the whole nine. So,
well, one good thing I know about TPRs, termination of parental rights, you can demand a trial by jury in this country, in this nation. Now, I don't know what it is in Canada, but if they even have to play by their own rules, man, that's sweet. Yeah. So you could find out. Like, just make a couple phone calls. Don't say your name is Jesse, you know. Just say, hey, you know what, I'm just wondering, you know, talk to somebody in another county or something like that. Ask them, you know, say, hey, you know, when it actually gets down to a trial, see, because that's going to be a trial. All this other nonsense is a hearing.
Yeah.
I went to 2 TPR trials, and both times when I went to trial, you know what the state did?
What's that?
They said they did not want to prosecute it this time. They wanted it dismissed without prejudice so they could come back and try me again some other time. But at this time, they do not wish to terminate my parental rights. So you understand how beyond upset we were because we wanted to be done. We were like, please take us to trial. Let's do this. Let's get the jury, let's get it on. And as soon as they realized, now it's the trial. Now Karl's got the chance to put us up on a witness stand. Now Karl's got the right to do this, this, and this. Now Karl's got all kinds of rights because this is a trial. At hearings, it's a Mickey Mouse. hearings are totally nonsense. So if you want to say, good, you got to get this different attitude, and you women got to get this that different attitude like I did, because I was like, when do we have like a trial? They're like, well, that's a termination for our rights. Oh, let's do it today. Can we do it today? And you're like, no, that's supposed to scare the bejesus out of you. Oh, no. Let's do this now. And you're like, no. All the parents avoid it, and it's like the plague, and they're scared shitless. No. You're saying there's something called a termination for rights, and it's a trial, not a hearing? Oh, can I put them on a witness stand? Yeah. Oh, let's do this. And like, no. We usually have to work with you like 16 months or 2 years before we actually terminate. No. Terminate my rights now. Let's get the trial on now. Do it. Let's do this. And I was freaking them out. Because that's the only time when, like I said, if I can have a trial by jury, and when do I get to cross-examine these clowns? When do I get to put them on a witness stand? Well, that doesn't happen until the trial. Well, when does the trial happen? Well, first we go through all these, adjudication hearings, and we try to see what the placement hearings, and then we try to do a dependency, deposition, dispositional hearings. I don't know if you guys have a dispositional hearing up there, do you?
No, just the regular hearings to see who's getting their counsel, if they have their counsel, and then the pre-trial conference with the defense had.
If you hear somebody called dispositional hearing, it's just saying, what position are we in? It's like a preliminary hearing. That's all a dispositional is.
Okay.
Do you guys use a fancy word, or you just call it a preliminary hearing? Is that what you guys call it?
We call them G hearings.
Okay, a G hearing.
Yeah.
Like a letter G?
Yeah, just to see everyone's position.
Okay, down here they call them dispositional hearings. So I was so tired of even thinking about another hearing. It's like, when do I finally get those clowns upon a witness stand? Well, not till the trial. Make the trial now. Just a dispositional hearing. We just want to see how the kids put that. Let's get it on. Everybody's here. Let's do this. It's like, no, they need time to prepare their case. What case? Let them get it on. I'm all in. You're like, whoa, wait a second. I'm all in. Let's do this. Terminate my rights right now, man. Let's get this on. Because if it's under your silly administrative things, I could take this over into my court. So you just get it on in the administrative court. Let's get this on. I said, if I lose, I don't give a rat's ass. I'm going to take it over to a common law court. Okay. I'm going to get a damn jury. Let's get this on. And you're like, oh, shit. And like I said, both termination and parental rights hearings, I wonder if I got the paperwork for that. And I'll make it available. I'll show you guys that the state withdrew their claim, or their willingness to prosecute it this time. They said, well, we don't want to prosecute it this time. They're working with us. I said, work with you? F you. How many times did I say F you? She's not working with you. I'm not working with you. F you. We're not working with you. We're never going to work with you. F you. Well, we don't want to prosecute them at this time. We see they're making efforts. Effort is what? Telling you F you? The judge was like, this is crazy. I mean, the second time, man, I exploded, man, in court when they said that they're not prosecuting it this time. Because I really didn't know the rules of administrative compared to common law. I thought I was in common law. I could have sworn I was. But like you guys did, you make a couple of simple mistakes and boom. You just said something wrong the wrong way, poof, I lost my court. I was like, hey, I thought I had my court. And then I go back and I said, oh my God, I did use one of their codes, didn't I? Oh my Jesus, Lord. I did use code like 36.1.51, subsection E. Oh geez, I did say that in court, didn't I? And I lost my court. Because I didn't know. It took me years to realize, oh my God, don't ever use this stuff other than as an exhibit. Because like I said to people, everybody laughed because they changed the code on me. And I was actually describing something really bizarre. I'm like laughing, so what's so funny? And then there's like, I guess you didn't get the memo. Alabama changed their codes January 1st, and now it's like June. I guess you didn't get the upgrade in your code book. It's like, well, no, my code book was like, I don't know, written. It's in the library, I don't know, 5, 10 years, I don't know. So part of me, they changed the code just because they knew a clown like me was writing briefs according to their code. So they're like, ooh, let's change this code a little bit. So when he says this, it sounds really ridiculous. But I was slamming codes at him. I mean, I was walking around like these guys you hear on these shows, and he was being able to whip out codes. Whoa, whip out this, Section 31, Section 33, Section 1 of the Canadian Charter. This is ridiculous. I was good, but it was ridiculous because they changed the code, and they specifically did it to me. And I went back and I looked up and on the internet, oh, you clown. This is exactly when I was submitting this. Oh, these people are smart. So everything that I wrote was thrown out the window.
Yeah.
Because it was the wrong freaking, I was trying to use their words instead of using mine. So like I said, thank God I went through 28 hearings and 2 trials, because it really made me learn, stop using that nonsense, and that's what the judge actually told me. I actually went around like I had, like you would see when the judge was pretty nice to you guys, whatever. I was going around with this judge, because he let me talk, which was ridiculous. He let me talk for about 7 hours, which no dad gets to talk for 7 hours. He said, you got the floor. Convince me. The sun's not going to come up tomorrow. Go ahead and do it. Prove it negative. So I was like, yeah, thanks, buddy. So I tried it, and after a while, he just gave mercy on me. He said, come up here. He gave me his business card. He said, look, let me just pass final judgment. Meet me on the hallway. I'll show you how to beat the state, and I'll show you how to return my ruling. And he says, oh, and you know what? The biggest favor you could do for yourself? Never use this damn case file number ever again. He's like, what? I said, but this is the case, and the kid is under the case. I said, don't. Man, I went around for this guy for about 15, 20 minutes, easy. I said, but I need this case. I need this. He says, it's not your case. So what do you think I get adamant with you people? Because I was the clown yelling at the judge, but it is my case. And it's like, it's not your case. My kids are on it. It's not your judge. He's like, stop, Paul. But judge. And he said, go file him. But judge. And it's like, we went around. It was so funny. He was like, oh my God, I'm going to have to hit this guy in the head with a hammer. It's not your case. But my name's on it. It's not yours. And man, he couldn't explain too much detail because the state attorney general was sitting right on the other side of me. He would say, hey, judge, you're not supposed to tell this guy all this. Come on. Tell him a little bit, that's fine, but, come on.
Yeah.
You can't tell him nothing.
Away all the secrets.
Yeah, just tell him, just warn him, don't use this case again. Don't come back to family court and don't use this case again. Case number again. I said, okay, well, what court do I take it? He said, take it into any court. District court. I don't care, but don't come back here. I was like, but that's what it just stop. It was so funny. You can't imagine this poor guy trying to help me, and it's like me trying to help you guys. I'm like, stop. I'm playing what he did to me. So that's why I'm too upset, because I see what you guys are looking at.
Yeah.
You got a couple of years of getting your brains messed up by watching the silly stuff on YouTube. And fortunately, YouTube wasn't really around back in 2001, so I really didn't get my brain messed up as bad as you guys are. But now you're visually getting it. I used to just hear this stuff on the radio. Now you guys are hearing it and seeing it visually, so it's really getting pushed down your brains.
Right.
It's embedded. Now you could actually remember seeing a guy on an overhead projector and pointing to the Section 1 of the Canadian law, now Section 33, and oh my God.
Now, Karl, they have their trial for this, not this coming week, but next week, 5 days. And we're not sure, we're going to be trying to put in our claim again this week. When we put in our claim, should this kind of stop their trial, put it on hold until our claim is heard?
You say since there's all the parties are going to be convening on that claim on that day for that hearing, well, we're going to have my claim heard at the same time, because we'll try to limit the expenditure of county resources or Providence resources and province resources, whatever you folks call it up there. Are you in a county or province? What do you guys call it? District? What do you guys call it?
It's a province.
Okay, well then you say I'm trying to, mitigate, any kind of, wasteful of, court facilities while we're all going to be here. We're going to have our trial for the return of property at the same time, and you could actually make a claim for compensation at that time as well, because that's the or else part of the claim. Because nobody's really going to take your claim serious unless you throw an or else in there. Like I told you before, don't put a compensation thing at this time. Get your kids back.
Right.
They're not going to take you serious. You say, you know what? Maybe they'll take a dollar amount serious. Because that's what the Department of Justice man told my whole family. Because I said to them, he said, well, how much are you going to sue for? I said, I don't know, what, like $1? He says, no, they're not going to take you serious. They're going to give you $1. And he said, no, don't do that. He said, you better put a big number in there and make it a whopper. He said, they're not going to take you serious. So don't make too ridiculous a whopper. Just say, I want $10,000 a day. Something like that. I'm not telling you that's what don't, literally say, do what I say, but don't make it like ridiculous, like $1 million a day. Make it just enough that if you don't mow your lawn, the Providence is going to charge you $1,000 a day until you mow your lawn. You see what I'm saying? So it's like, well, hey, you charge us $1,000 a day if we don't mow our lawn. I want $10,000 a day or $4,000 a day for each kid.
So basically, our claim is, we want our property back now, or else we want this amount until it's returned.
If I'm holding my property, you could use the word like full bracket naked possession. without rights. That's all it means. But you don't put naked possession on it because that's a legalese word.
Okay.
You use say holding possession. You put naked, four corners, so that way they don't read legalese on that document. To say naked possession of my property, I'm going to demand $1,000 for each piece of property that's being held by four different individuals, or one individual holding all four properties, or how people decide to scatter. I'm going to actually go after those people who are holding my child in their possession, my property in their possession.
Okay, so we're basically going to put in our claim, and we'll say, for the sake of not wasting resources, we'll have our trial in the same time that they want to have their trial, but we're going to have ours heard first, basically.
Mm-hmm. So what I would do is I'd find out if you say foster care parent X, Y, and Z, or foster care parent John Doe, or foster care parent Jane Doe. If you don't know the foster care parent's family that they're holding in, say I'm going to charge the family, $10,000 a day until I return the child from my custody. You could go after the foster care parents too. They could definitely be sued.
So we can put them all on there, basically the social workers, the foster parents, all those people we can put on the claim. That's good news.
Yeah, so like I said, we could work on a little bit on the compensation thing if you want a little bit. But like I said, I've read, like the Alabama Code, I think it's under Title 36, like Section 1, Section 5E, where it basically says that foster care parents can also be sued and can be held liable. And that the risk management of a general liability trust fund sets up an insurance policy for when a foster care parent does something wrong to somebody's child. So like I said, you almost want to make your kids like lepers, that nobody wants to touch your kids at a foster care home.
Yeah, basically.
To be afraid to accept them in. Regardless that the judge gave them an order that they could walk off with your kids. It's like I said, it's like everybody knows it like that German thing, just because Hitler made an order that they could kill all the Jews. The guys who killed all the Jews actually died after World War II.
Yeah.
So they're going to be like Nancy. It's like, can she do this to me, Judge? Like, if you watch that, I don't know if you ever seen that old that video, because they came out like last year, that old English guy. Remember, he was standing in, I don't know if he's standing in a Queen's bench. No, he was not even standing. He was standing in some silly, like an equity, a court of equity or something like that over in England. And the magistrate told the bailiff to throw the old man out of there because he did something like you did. He wouldn't give his name. So he's like, the man that you're looking for is on that person to be in front of the court. He did that stuff. And then the magistrate just had enough of the old man's nonsense, and he told the bailiff, remove that man from the court. As soon as the bailiff went to touch the old man said, I do not consent. Do not trespass against my person. If you touch me, I will sue you for everything you got. You will work for me. I will garnish your paycheck, and I'll take your pension. Don't touch me. So the bailiff turned around, looked at the magistrate, the judge guy, and said, can he sue me? And the magistrate guy didn't say anything. This is on YouTube. And he said, Your Honor, is this man telling me the truth? Can he sue me? And the judge didn't say a word. He said to the old man, hey, I didn't touch you, did I? He's like, no. I said, well, I'm sorry. The bailiff walked away from the old man. The crowd in the audience went bananas. So like, oh my God, the old man pulled it off.
Do you remember what that video is called, Karl?
I'll send you the link. I'll put it in there. I showed, what's his name, Greg. But he's having something to do with tax return right now. And I'll send you the link. It's hysterical. It's funny. A little guy, he looks like a Mr. Whipple kind of guy, a little round-headed guy, this little heavy guy with glasses, little old guy. He looks like he squeezes toilet paper for a living. So he's not really a protagonist. He's not really somebody who looks, antagonist like he's, rabble-rouser. But he just knew the law. Don't touch me. I don't consent, and no man may touch another man. I don't care if that guy in the black robe told you touch me, and you're a cop. I told you don't touch me. You touch me, and I'm going to sue you. And the judge, like I said, that was great, but the bailiff said, can he really sue me? And they said, Judge, you're an old judge. He was like, the bailiff was like, over here, can he sue me? The judge was saying, he's like, oh boy, he's like, man, I'm not hanging with this old guy, man. He knows the law, obviously. So,